Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I'm a financial mediator and business valuation expert in St. Louis, Missouri. Today, I'm speaking with Kelly Lise Murray about handshake deals, huge numbers, and why agreements can collapse on appeal. We're discussing an interesting topic today, and it's about kind of case reviews, which again, a lot of times in the valuation community, we're looking at case law, case precedents, what does it tell us about the various areas of valuation? And Kelly brings a very unique perspective to these cases and has actually, we're probably going to do a series because we can only cover one case in this podcast because it's so big, but it's really where is the intersection of valuation, of law, maybe even a little bit of mediation and negotiation in there. So welcome, Kelly. How are you?
I'm doing well. Thanks, Melissa.
This is awesome. So why, we're going to be talking about cases, and I guess from some standpoint, a lot of people don't enjoy this as much as you. I think it definitely gives, I think you have to understand, if you're a testifying expert, you have to understand like what is happening, where people are failing, where people are succeeding, because, juries and judges are logical and valuation theory is very technical, and sometimes it gets lost and confused. But like, what is so interesting to you about reviewing cases and the impact? Because what's your background and some things that bring you to this interest?
Well, I'm a lawyer. I've had my law license for over 30 years. I have degrees from Stanford and Harvard Law School, and I taught at Vanderbilt Law School for 18 years. And while I was teaching at law school, I had a side interest in wealth disputes, divorce, estates. But when people disagree about wealth, whether it's real estate or other assets. And the key thing about cases that I learned from all of that, so I build my continuing legal education and continuing financial education classes on litigated cases, because litigated cases show us some of the craziest facts you would think are totally made up, but they really actually went to trial and went on appeal. But besides that, it shows us what a judge and separately an appellate panel did with key issues that may impact a business valuation or impact testimony in a case someone's working on right now. That's why I'm so passionate about actually litigated cases. It shows us even more about what works and what goes wrong and why it went wrong, so we can prevent those mistakes and build on the positive.
Well, and it's interesting because like in the cases that we're going to talk about, it's even one level deeper, because what interests me about these cases and the topics is because you wanted to talk about cases that went to appeal. And I think that is, like there's testifying experts, there's, going through the process to get a case through. There's only been a handful of times that I've had to come back on appeal, like the appeal, they filed an appeal and then it got sent back down to the court, right? And really only a smaller amount of time was I go in and testify on appeal. And it was because I said, you know what? If they got it wrong the first time, there was some sort of misunderstanding, right? If this is a difficult concept, then we missed the mark on just providing a brief or a report. Like I need to add the layer of context of testimony. But your focus on these cases is that, what happens, not necessarily in the original case, but what happens on the appeal and what can we learn from even that process. And so I think it's just fascinating. And again, you and I might like this stuff a little bit too much, but our audience is also, other valuation people, business owners. And this is a case that we're going to talk about today that actually brings so many different things, like it was originally a divorce case. It then becomes like a business case. It has business valuations. It has startup companies. It has transfers. It has an agreement that is also, we don't know if it's mediated, but it was definitely agreed to with maybe not the proper financial and legal counsel And, what happens in this agreement kind of carries throughout the case and the appeal. But we probably should just start with you giving us kind of a background on the issues in this appellate case, which was Kay versus Yosowitz. And we're going to put the in the show notes and things like that, we'll put the actual case details. But what were some of the major issues in this case that you found interesting?
This is an October 2025 appellate decision. And the first interesting piece for me is that the appellate court did a do-over. So the original appellate opinion came out a few months earlier. They take that back and release this new decision. So in this appeal is after a 2-week jury trial on a marital business. So it's not the divorce, this is post-divorce, a 2-week jury trial. And what was at issue is the value and the wife's share of the marital business. It all hinges on one document that was many years earlier at the start of the divorce. So this marriage started in 2001. In 2014, they begin a startup business. And the marital business, the startup, has 2 separate businesses. Half of it is real estate brokerage, just like any sign you'd see in your neighborhood, offering, they could help you sell a house, they could help you buy a house, they could do commercials. So that's one part of the business. The other side was a software, but more like a software light. It was a spreadsheet-based calculator to help buyers and sellers evaluate properties. Some data scraping, some of that. And it's not very successful. So 2014 is when the business starts. The end of 2015 is when the marriage challenges begin. And in February of 2016, one of them files for divorce. The divorce happens the end of 2016, but in the midpoint, around July, according to the wife's appellate brief, the husband is threatening to not work on this startup business anymore if she does not agree to what they're going to do with the marital business. And that became a memorandum of agreement. And the memorandum of agreement had no lawyers when it was negotiated. It was the husband and the wife. The husband was represented by someone who later becomes a financial investor in his post-divorce business. And the wife was represented by her brother, who has financial credentials, an MBA, a former investment banker. So he has the credentials to help her with this negotiation. But my concern, given that this is the central reason of the result in the appellate case, is what was missing from that negotiation. And things that were missing included a business valuation of the marital startup business, legal representation. So there wasn't divorce lawyers, there wasn't intellectual property lawyers, and there wasn't corporate law input either. And all of those things work against at least one of the spouses on the appeal. So that's what stands out to me, is that they go through a 2-week jury trial on this business and what the wife's owed. And it's all controlled by a document that had apparently almost no legal input and no business valuation input.
And I think because we've talked about this case at length, but I think some of the other issues were also, she had a marital interest in it, potentially a profits interest. This was more of a startup that was also being created. And, even in the agreement, she agreed, one of the things that I think is important from a valuation standpoint, she agreed that the IP, or the intellectual property, was to be transferred out of that company into these other companies, right?
Right. So the memorandum of agreement, and this becomes the basis for the appellate decision. They're restructuring, but they don't describe it as restructuring. So the marital business is called Greenlit. In the agreement, they used placeholders. So they were supposed to create, or the husband was supposed to create, a placeholder called Holdco. That was going to be the holding company. And then IP Newco was going to hold the intellectual property. So this real estate related spreadsheet calculator software was going to go into IP Newco, which would be owned by Holdco. And then the ownership of Holdco percentages would be what they were under the original Greenlit. And that looks fine. maybe sitting at the table. Oh, we're restructuring. That's how the wife viewed it. But legally, and this is in the appellate decision, the restructuring required the marital business to simply gift its intellectual property to IP Newco, to just gift it for no value. And based on later legal representation and arguments that are presented to the wife that are pursued at the trial, the memorandum of agreement actually works against the wife for that exact reason. And so that's why I'm sure at that time, no one's thinking the wife is going to have to sue the husband on behalf of the marital business itself. She had a derivative claim. So she has direct claims he's breaching all kinds of things. And the jury agrees with her on many of those things. But she's also suing on behalf of this marital business that gifted its intellectual property to IP Newco, which was never created. So some additional facts here are they agreed to restructure, and the husband's argument is, well, we can't get any outside investment if investors are worried our divorce is going to affect the business. That makes sense. And they agreed to what what the wife viewed as a restructuring, but legally it was not a restructuring. It was simply stripping the marital business of its main asset for no value. That's how it plays out legally.
And I think, because we're going to talk more about the case, but at the end of the day, we go all the way back to a negotiated agreement outside of court. Again, whether it was in mediation, however it was negotiated and then written up in the divorce, right? So we have maybe a divorce attorney.
Well, it's a term sheet. So they describe this memorandum of agreement as a term sheet.
Yeah. And
because
so
it wasn't written by lawyers.
And like her brother's an investment banker, no shade to investment bankers, but they are not valuation experts. So they're constructing a deal, if you will, and they're engaging into this deal into a divorce litigation, which again, a lot of times divorce attorneys don't see complex valuation issues all the time, right? So you probably don't have the right people at the table. But the other thing, and we've been talking about this a lot lately, is that you're hiring these people in the context of whatever litigation you're in, knowing that, are thinking that they're giving you, decent advice, right? And you're like, well, I have financial advice. Maybe I don't need all of the legal advice because this is simple. Or I have the legal advice and I don't need the financial advice because this is simple. It's a startup. Like both of those positions, if they had been taken and a combo was taken, is not going to get you the right information. And now, the divorce lawyer is like, okay, looks like you guys settled this and everything seems fine. Now she comes back and comes to a business claim, right? Which is the issue in this particular appellate case, is that she's coming back for a business claim, which again, they had agreed to certain payouts. And we'll give some idea. Like, the payout was, I think, like 3.75, and then maybe another kicker of a bonus of 500,000. So let's
that
say
was
4 to 5 million.
But that was a cap. That wasn't a guaranteed payout. That was the husband's side viewed that as a cap. So basically, from the facts, and there's not a lot available. And the difference between the divorce trial and the appeal, and if there is one, and then this business trial and the appeal, the only things we see on appeal is what was objected to. Everything that is not objected to is technically invisible on appeal, and that's the instance here. So we're really focused on this claim where it's the wife bringing a claim on behalf of the marital business. So it's a derivative claim. She had a marital interest in that business, and there were issues of whether she was actually a member of that LLC. So on appeal, at the divorce trial, at the business trial, it's a 2-week jury trial, including many claims, and she wins with the jury on many things. But the appeal is focused on 3 issues surrounding this derivative claim, because that was the big ticket within the jury's verdict. And it was obvious that the husband would have appealed it. But all of this turns on the memorandum of agreement. And one fact I want to throw out there, it's important to keep in mind when business interests collide with a divorce, anything you negotiate and agree to early on is a binding contract. And that's why it's so important. If the business is a significant asset in a divorce to make sure you have the representation to give you the information before you agree to anything about the business. That's the opposite of what happened here. And that memorandum of agreement, that term sheet, had binding terms that no one could change without husband and wife both agreeing. And so
Yeah.
that's what's really the limiting factor later on.
And then the crazy part is that, this is between like a couple $1,000,000, which was agreed upon in this contract of like what would happen after the divorce, based on the success of the business, based on investors and things like that, to a 50 plus million in, award from a jury in this derivative case, right?
Right.
And so like that's how different the numbers were. So anytime you're going to have a 50 plus million, award, you're going to go to appeal, right?
Absolutely.
And so then the appeal is where it kind of gets interesting and starts to break down. And again, like it's so in depth that I think that even as business valuation experts start to look at this case, it's going to just create so many questions, so many like concerns, like how did we get to this point? How did they get it wrong? How did they, is it even right at this point? Because there was lack of foundation for a business valuation. There was lack of the appropriate legal representation because again, if you're into a divorce, you're more concerned about the divorce issues, not really understanding the implications of what you're agreeing to. And did you pull in the right people? But at the end of the day, if again, that is your major asset, then it's going to be the best idea is to get either a second opinion, get other people involved. Like we've always pulled in, for the most part, divorce attorneys are not necessarily equipped to deal with these very highly complex cases. And so pulling in an IP attorney or a transaction attorney, because a lot of this, like this is almost like a post-transaction, litigation in some capacity.
It
right?
absolutely is. Because a key fact here, the memorandum of agreement required the marital business to divest itself for no value of its intellectual property. And that's one of the main holdings in the appellate decision. But the husband does not create holdco. The husband does not create IP newco. He tells the wife, and what is disturbing to me as a lawyer, he has a lawyer represent to the wife and her attorney that these companies have been created, and that's false. So there's a whole lot going on here. The big villain in the jury's eyes was the husband. And it looks like there are a lot of facts to back that up. So he does not create holdco. He does not create IP newco. But what he does do, the date, one of the key dates in the divorce. So the memorandum of agreement is incorporated into an agreement incident to divorce, and that is specific to Texas. This is a Texas divorce. It's incorporated into the agreement incident to divorce. It's an agreed divorce decree. That same day, the husband incorporates what will become his wildly successful post-divorce business in Wyoming. So the same day he signs the agreement incident to divorce, he's already taking steps to do something. And the issue is, are they totally different businesses? That's the husband's argument. Or are they really an extension of each other? That's the wife's argument. Or are they somewhere in between? We have evidence in the appellate briefing and the appellate case itself that there's overlap. But the appellate court disagrees with the wife and agrees with the husband that based on these being separate corporate entities and the marital business simply giving away its being required to give away its intellectual property, it just pulled the rug out from under the wife's derivative claim on appeal.
Yeah, and it's interesting because a lot of times, my limited understanding of appeals are, that sometimes they're fought via briefs, right? Like these briefs come in and they're filed, like what did the jury get wrong? And again, like most people don't encounter a jury unless you're going to be like in a federal court or a federal case. Like it's not going to be like these steps from a divorce case, right? Now, although
2 weeks, it's a 2-week jury trial. That's huge.
Now, in Georgia, you can actually get a jury trial for a divorce case, and there's some other states, but I think, okay, so let's get into this case a little bit more. Like, what was some of the surprises maybe that you saw in the case? Because again, if this is of interest to you, we would absolutely recommend that you read the case, but we're just kind of giving you some highlights of how something can go wrong without without having the right players involved, and also with agreeing to things that you think are very simple. Like, these term sheets were very simple, right? And the nuances of them were extrapolated and taken to the extreme. One extreme was, a jury award of 50 plus million, and where you had the agreement was just saying, hey, we will eventually pay out at the most under 5 million, right? And now you have, like you've even said, like, why was this even litigated? Because it was almost like dead on arrival. But what were some of the things that you think are important from a valuation legal perspective as well?
The main thing is the wife has direct claims. So the wife wins a lot, and she wins things we don't know about because they're invisible on appeal. The main issue in this appeal is her derivative claim. So this is the wife claiming to be a member of the marital LLC. So it's a Texas divorce. The LLC was incorporated in Nevada. So the appellate court calls it a foreign LLC. The husband is the only member. So one of the three issues was, does the wife even have standing to bring a derivative claim on behalf of the former marital business? Because the husband was the member, the wife was not. And her only piece of evidence, or the main piece of evidence on appeal that actually helps her win on the standing issue, is the year that they started the marital business, 2014, a K-1 was issued to the husband and the wife for the profits. And that taxation confirmation helped her on appeal that the jury had at least some evidence to find that she was a member. So she wouldn't even have been able to bring the derivative claim if you just looked at the husband's argument, you just looked at the incorporation documents, that husband's the only member. Outsiders can't. And in the appellate briefs, the husband's lawyers point out that a spouse of a member is usually limited to bringing a derivative claim after the death of that spouse, and that makes sense. But here, that taxation confirmation. So it's interesting just how the evidence comes from wherever it comes. But in 2014, the year of origination of this business, real estate brokerage on one side and Excel spreadsheet, data scraping, calculator business, intellectual property on the other side. So then the other is the cap. Husband argued on appeal that the wife can't get more than 4.25 million. So it's the 3.75 ceiling that was agreed to, a $500,000 bonus, and then another $750,000 to be set aside for their children, only if the marital business was bought out, if it got investments. So those were thought about at that memorandum of agreement stage, but it's more that term sheet. It listed those things, but it wasn't binding on the husband in the sense of he only agrees to spend 12 months from 2016 to 2017 putting best efforts forth on the marital business. After that, he can do what he wants, and he does. So the wife wins on standing mainly because of a tax document. The cap is not a cap. The court gives various reasons, but one of the reasons is the husband was supposed to create Holdco, was supposed to create IP Newco, which was going to divest the intellectual property from the marital business. He doesn't do either of those things, and the appellate court held, well, since he never created the entities that could have capped the wife's recovery, there's no cap. So she wins. That looks great. She wins on that. But the main part of the appellate decision is the derivative claim itself. And a claim here, you have to show duty, breach of duty, causation, and damages. She loses on the damages, mainly because the number she and her valuation expert came to was that the wife was owed 13.6 million. That's what they argued in closing arguments. That was in her financial expert's report. She's owed 13.6 million. The jury values not the marital business. Her own expert didn't value the marital business. The jury looks at the wildly successful post-divorce business and comes to a valuation of 138 million. And then the trial court and the jury give the wife a marital share of 54 million. All of those numbers are wrong, by the way. And even if it was right, she still wouldn't get 54 million because the memorandum of agreement only gave her an 18% interest, not a 50% interest. So there's a whole lot of math that goes wrong, but it all comes back down to what I find interesting is footnote 13. I want everybody to read footnote 13 because it really looks like the wife's financial expert is boxed in, that he's asked to value the wildly successful post-divorce business. He never values the marital business. And that's the disconnect that is really the crux of this appellate decision. What is the measure of damages for the husband failing to create holdco, failing to create IP newco, and simply abandoning the marital business? Because she's not going to get 3.75 million if the marital business has no business. That was a ceiling.
Yeah. And I think that that was an important nuance that you brought up because, again, a lot of times we're brought into cases and the attorney's saying, okay, here's what we need to look at. Here's what we need to do. This is going to be our best position, right? If we value this wildly successful business and it's a proxy to what the business was before. But in this situation, the business that was the marital business still existed. It was there. So there, and again, I mean, everybody can point fingers, but it's professional due diligence of doing some of this legwork and saying, and as a valuation person of pushing back and saying, because I tell people like I'm the financial quarterback and the lawyers are the legal quarterbacks, but I need to know, is this the proper way of looking at the case from a valuation standpoint, as opposed to just doing what is best for the position of the case? Because foundationally, if I fail in the proof of my part, right, then all the numbers are going to kind of collapse. And so I think in this situation, it wasn't really understanding, it was more like looking what would benefit the case as opposed to what are we actually looking at? Well, like, what are we actually valuing? What is at play or at, in this discussion or this argument? And are you in over your head, right? Because you even asked at the beginning, you're like, okay, well, do you value startup companies? Startup companies are the most speculative, right? Especially if there's IP, especially if there's transfers. In my opinion, this case should have been vetted or understood a lot more at the beginning instead of getting these pie in the sky kind of ideas or numbers. And again, I mean, you could say, okay, he was boxed in, but at the end of the day, what was his professional due diligence to understand that that was not the appropriate thing to value,
And apparently in the husband's appellate brief, apparently the wife's financial expert didn't have any understanding of the businesses at issue. And so one argument is the husband saying my wildly successful post-divorce business totally different. Wife saying it's totally the same. There is evidence of significant overlap and actually piggybacking from the marital business. And the reason why the wife does not win on those factual issues on appeal is back to that memorandum of agreement and simply divesting for zero value the intellectual property. It just cuts her up. And it allows the court to disregard, to not rely on any fact finding by the jury, because this is on appeal here. This was a contract dispute and statutes were at issue. All of those are questions of law. So there's no deference to the trial court. There's no deference to the jury. So this appellate court looked at this and concluded under the memorandum of agreement, it was impossible for the husband to have breached a fiduciary duty to a company regarding the software that it was required to just divest for no value. That's really one of the key findings of the appeal. And so that goes back to the structure of the restructuring. The memorandum of agreement was not structured correctly. It really just, the appellate court is not wrong that simply giving away a company's intellectual property, if you're required to do it, then the managing member didn't damage the marital business. He divesting it was what he was supposed to do.
Right. And I think that the valuation issues surround like using it as a proxy. So valuing this company as a proxy because he benefited from both. But the nuance in that agreement was that she agreed with him that the IP would have been transferred out of the company, that she had ownership even from some sort of, an interest in. And
It's
that is
community
also,
property. She
yeah.
absolutely had a community property interest. But that's where even one thing I want to just point out is before agreeing to anything like this, everybody has to role play. What if the other side doesn't do what they're supposed to do?
Mm,
And there actually was an attempt to put a non-compete into this, into the memorandum of agreement, and the husband disagrees and ultimately it comes out. But that's what he did. That's what the wife's arguing he did, is that he was competing with the marital business, took out
mm,
he actually technically licenses from the marital business to his wildly successful new business this spreadsheet calculator. He uses the same software developer in India from the marital business for his new wildly successful business. The wife's due diligence, she finds that in the source code of the wildly successful new business is the name Greenlit, which was the marital business name. So its source code is in the new code. And that's why she's arguing the overlap. But the appellate court rejects all of that on the derivative claim because of this memorandum of agreement where the marital business was supposed to just have nothing software left for no
mhm.
value.
Yeah.
So, and the court points out no license, no sale. So just that simple difference, if the memorandum of agreement had required the software, even to the new company, to be licensed back or some kind of value. So what the biggest problems for the wife's argument is the restructuring itself. If the marital business hadn't been restructured, then the software still would have been owned by the marital business and all of that. So this was a number of factors that really worked against her. And that's litigation. That's why you get the financial information, you get the business valuation information, and then what we've talked about, intellectual property legal advice, corporate structuring advice, but all of that was missing, and is what undercuts on appeal what was a $138 million verdict. Her share was 54 million. All of that gets reversed on appeal because it's the wrong company being valued.
Yeah. And I mean, to me, the reason why we're going to be taking a look at a lot of these appeal cases over the course of maybe next year is because this is a lesson that you do not want to learn. This was a
Yes.
very expensive lesson, a 2-week jury trial that she had to pay for, which I don't think she got her legal fees back at
So
the end.
okay, this is another
Okay.
insult to injury.
Yeah.
Because the 54 million cannot stand, it's legally insufficient, valuating the wrong company. It's not the damages of the marital business. She also loses the award of investigation costs. There's a Texas statute under which if she'd gotten any kind of money, if the marital business had been able to prove any of its own damages, she would have gotten legal fees and other investigation fees. That gets reversed too.
Well, but there's also a point that I think you made when we were talking about this, about how she brought the derivative case upon the wrong company, on behalf of the wrong company, right? Like,
Oh no, she only has an interest in the marital business. The Holdco and IP Newco were never created. She would have had an interest in those if the husband hadn't breached the memorandum of agreement. So the husband doesn't do what he's supposed to do. He blames both of them. The jury disagrees with him on pretty much all of his facts. So she brings the right claim, but she can't prove its damages. And the main reason she can't prove the damages, according to the appellate court, is divesting the intellectual property for no value. And that
yeah,
was in the memorandum of agreement. So that's what makes her derivative claim. She succeeded with a number of hoops that would have prevented her derivative claim. She has standing. She isn't capped, but she can't prove damages for the marital business. And the other challenge with the marital business is, and this is where this happens in divorce, where one spouse has economic advantage. Here, the husband had business advantage because he was the driving force behind this startup business. And he, according to her brief, was threatening her. The year of the divorce was 2016. 16. And in that year, midway from the filing in February, this is around July of that year, they get divorced in October. So around July, the wife's brief is asserting that the husband's threatening to stop even working on the marital business. Well, then it would be worth nothing to both of them.
Mm-hmm.
So this is that rock and hard place situation that many divorce negotiations have for people.
Mm-hmm.
And that's why, and courts don't save you from your own bad deal in divorce. That's not the court's job. You're allowed to agree to a bad deal. And as long as you're aware it's a bad deal, that's it.
Yeah.
So the permanence is really important.
It coming down to like one sentence or one piece of it, I think is so important, like reviewing these cases. It may not have direct, because people are like, well, this is a Texas case, or this is a, like divorce is different in my state. Yeah. But at the end of the day, as we're moving more into mediation, as we're starting to be financially involved in some of these negotiations, it's going to be important. And specifically, if you're the business owner as well, to have a second opinion, to have other people look at it, to get a business attorney involved, but not just like your friends, cousins, brother.
Your brother, your own brother.
Right?
Bless his
like
heart.
This is, and financial, because we get these people involved because it saves time and money at the beginning. And we think, we've argued a great deal at the beginning. This little tiny nuance is a lesson that none of us need to learn the hard way. And so understanding it, yeah.
It's more universal corporate law anyway. This is not unique to Texas. This derivative claim would play out the same way everywhere else if you value the wrong company. So it seemed shocking to me at first because the blurb on the case is valued the wrong company, $138 million verdict overturned on appeal. Those are all true statements. But what it turns on is so much, it's right from the beginning. Right at the beginning, when people are low information, no information, low documentation, no documentation. And so really take your time. Do not decide your most important assets at the start.
Yeah. And definitely, like we're seeing a lot of these mediation agreements just in general in divorce in a lot of states, because we're working around the country, and it's really horrific. Like, and I don't know if it's just lack of like representation, if it's lack of hiring the right financial experts, like, or a combination of not having anybody really in the room looking at this, and then having potentially, oh, okay, so you guys have agreed to something. Let's just have our divorce attorneys write it up. Well, in the write-up of these agreements are going to be caveats that are saying, hey, you could have done more discovery. You could have done more investigation. You are entering into this agreement, and we're not telling you that this is a sound agreement, but you and your spouse are entering into it. Like, there's so much language that I think people are missing that are really allowing the divorce attorneys to not be culpable or liable in this situation. And if you're not reading these agreements again, right? If you're not understanding the implications. Now, I don't know if anybody could have predicted this one, right? Like, this was so nuanced and went through so many levels that, like, hindsight's 2020 is a rough one on this particular case.
The one thing
yeah.
I would say on that though is, if you're agreeing to something with your business and one spouse is supposed to do things, role play it out with your legal counsel. What happened? Because enforcement, this is a main issue, part of my legal scholarship, enforcement. How do you enforce it if the other side doesn't do this, or if diverts, here this was a 12-month effort to build up the business, and then after that he was free to not build up the business and she would never get 3.75 million. That was a ceiling, not a guarantee. So really look at, what if the other side doesn't do X? That's something that should be looked at. And it doesn't have to be a business. It could be paying you your equalizing payment or something with the retirement assets. But if someone's supposed to do something, really ask those questions of your legal counsel. What happens if they don't?
Mm-hmm.
And what can I do? Because that will help you put in more protections. And
well,
here, because there should have been a deadline to create those companies.
Yeah.
And if the software had gone to IP Newco and she had sued on behalf of IP Newco, the main argument that she loses this appeal on would have been gone.
Yeah. Well, and also like we talk about this a lot of times because there's a lot of times in these big high dollar, businesses, there might not be cash. So there's going to be a payment over time. And the enforcement of that payment, like even just one clause in the agreement or the, marital agreement can be, if I have to go and enforce this, if I have to go and make sure that you've done what this document requires of you, you're going to pay lawyers' fees. You're going to pay those fees for us to go back and basically litigate the payment or enforce the payment, because at the end of the day, you don't have any way to actually do it without going back to court, and that's going to cost you more money in order to get the money that you didn't get. And so I think that those kind of prevailing party clauses or things that, make it so that how are you going to enforce it, or what is the deadline, what is the results, because sometimes you even have to provide financial documentation for several years after the divorce. Like anywhere where there's going to be some continual process after the divorce, you have to get in there that if I have to come back to court, you're going to pay for this. Because and I don't know how much that covers it if it goes on to appeal, but it could have gone a little bit further in covering her for at least the expenses that it took her to get to this level.
Yes, those are really important things to keep in mind. And so this is a dual, this is a straight up 2-week business jury trial after a divorce. So it's both of those things, and that further complicates this one.
Yeah, absolutely. So, what do you think, final takeaways from this case would be that why you would think that they should read it? I think we've covered a lot of major issues, but if you want to summarize it, and then we'll kind of go into how people can reach out to you for these cases. There were a couple other cases that we were going to discuss, but we realized that we needed to take them one at a time. So if you want to tell them maybe about what to expect, on the other cases that we hope to talk about in the future, we certainly can as well.
So what I've been doing with my legal scholarship, both while I was teaching at law school and now that I'm focused solely on teaching continuing legal education and continuing financial education, is I wanted to show you what the actually litigated cases, what happened in them, what worked, but also what didn't work, so that you can benefit from others' mistakes and we can just improve the approach, the first time, so that when you go through a business dispute, you go through a divorce that has a business dispute, we get it right the first time and nobody has to appeal. Because even in this case, there are many issues that the husband didn't appeal because the wife straight out she won and there was no error. And so that's the best result after any kind of trial, is that there is no appeal because there is no error. And we certainly want to make sure that the business valuation is as strong as it can be. So the ways to find me are through vettingthehouse.com. And the reason why I'm doing this, I've started a podcast where I analyze wealth disputes. It's called Wealth Litigated. And I take cases where people disputed wealth distribution. So it could be estates, it could be trusts, it could be divorce. It's really interesting to me what worked and what didn't work, but I think it's essential reading for anyone in the business valuation space and financial services space to really see that what's going on, how did it litigate, because you're really limited in your access to those cases. I have access to the legal databases. And so that's why I'm so excited to share these cases with Melissa and with all of you, so that we can really just talk about what worked, but also what didn't work, so we can all avoid that in the future.
Yeah, absolutely. And I think that, talking about these cases or learning some sort of way to prevent these, obviously transferring IP is a very important clause, like from a valuation standpoint. So I don't think that that should have been looked at as lightly as it was. But, at the end of the day, you get a jury to come back with a $50 million claim. You have to understand that it's going to be appealed. You have to understand that, does it make sense, right, from what you had negotiated, and that, hindsight looking back and saying, well, I should have negotiated for more, or it should have been worth, because this companies did go through several rounds of funding, right? And so there were like big investment rounds, and I think the dollars just started to get bigger in everyone's eyes. But at the end of the day, a very large result is going to get more critique and more eyes looking at it in order to get it thrown out. So I think you have to consider, what you're entering into at the very beginning. What is it going to be really, is it's foundationally there, and where can you walk away, right? So at the end of the day, don't sign these agreements with just your family members giving you advice, and thinking that it is very simple, it's very concise, that it's covered everything, because these things can skyrocket and go in a completely different direction. But I really appreciate your take on it, as from a legal perspective. And I hope that it gives some of us valuation and financial people a perspective of, the devil's in the details. And this is one that just went way off the rails. But you find these cases that are very unique, that are not really necessarily being talked about, that have tremendous value. And like, this is not a lesson that I want to learn in the real world. Like, I want to read about it. I want to take it in under advisement and not have it happen to me. But
We hope that for everybody.
right. So, and we're going to have you back hopefully every quarter to kind of talk about it. But tell them again your podcast, because you're going to be going off of, like, if they want to know more about these cases, you're going to be doing this on a very regular basis and going in more depth to cases than we could possibly imagine.
Right. So, Wealth Litigated, wealthlitigated.com, the focus is what works and what goes totally off the rails in asset protection, wealth division. So it's a lot about trusts and estates, estate planning, a lot about tax and divorce, because divorce is the stress test for your asset protection, including your business and your estate planning and all of that. So if it's a dispute concerning the division of wealth or the protection of wealth, we'll be covering it.
Awesome. Well, we appreciate you, and I hope to have you back, and we'll talk about a few other cases. But for now, I think that this was a great lesson, and we will all benefit from it. So thank you, Kelly.
Thank you.